People versus Cruz. Counsel rebuttal?
3 minutes, Your Honor, please.
3 minutes. Go ahead.
Thank you. It is a fundamental problem when a court officer performs a judicial function off the record such that no one learns what occurred until years later. And that, I submit, is what happened here. Here there was a note from the jury requesting an exhibit, a statement signed by Mr. Cruz.
That wasn't in evidence.
Correct. That had, in the presence of the jury, been admitted.
And you're saying a court officer or a court clerk or somebody just told the jury you're not allowed to have it because it's not in evidence, and that was the end of it? No one saw the note?
Well, it appears from what the judge said at the reconstruction hearing that he never saw the note. I mean, he's not
doesn't recall
100% certain, but his statement is that if I'd seen it, we would have called everybody back in. So I take that to mean that it's highly likely that.
But counsel usually stipulates, I think they did in this case too, to allow the exhibits into the jury room without having to reconvene.
Admitted exhibits. That's correct.
Admitted exhibits, obviously. So this note came out, and possibly the clerk or the court officer or somebody said, this is not one of the exhibits that you can see, and that was the end of it.
It's uncertain because it was never brought, apparently never brought to the attention of the judge, certainly never brought to the attention of the defendant. We really don't know what happened here.
Where was the note found?
The note was only found when counsel for Mr. Cruz, who had this case originally, Mr. Donaher, was reviewing what we call the Brown file, which is all the papers that come from the county clerk's office.
So it was in the court file.
It was in the court file only, but it was never part of
the
the record.
Do you think that the fact that there was a note meant that the jury thought it was in evidence, that they were asking for the
Correct. I think that's a reasonable inference, that the jury is requesting the note, that they'd been told on the record that this was admitted into evidence. They'd not been told.
So what's the ramifications of that? If
The
they thought that it was in evidence.
That they thought it was in evidence means that the primary ramification is that means this is a substantive note. An ordinary note requesting something that's in evidence that actually is in evidence, as this Court has held, the request for a boulder is replied to by providing the jury with a boulder, the admitted exhibit.
In your experience, is this common in the criminal courts in Monroe County, where there's a stipulation that if it's only a request for an exhibit that can be handled without calling the lawyers back?
That is a common stipulation. And I believe under the decisions of this Court, attorneys really don't need to stipulate to it, that the Court is permitted to simply provide admitted exhibits to the jury because they're admitted exhibits. And
part of your argument, though, is that it has to be the court that does it, not the court officer?
Well, the crux of my argument is where there is a real issue with regard to the exhibit, that it's not the ordinary situation where the exhibit is simply provided to the jury because it's admitted, because they're entitled to it, without that, as this Court has held, there's nothing to discuss. It's an admitted exhibit. The jury's requested it. They get it. There's really nothing to talk about.
Are you asking for a general rule that every time the jury asks for something, the court officer looks at the request and says, sees it's a request they obviously can't have and says you can't have it, and it doesn't go to the judge? Is that always reversible error?
Where the record is clear that something is not admitted, there may be circumstances.
So it sounds like there's an implicit no, that not always in your answer. You're asking for a narrower rule.
Yeah.
Okay. Go ahead.
That here, where there's effectively the rule I'm asking for is that any time there is something to discuss, it should take place with the defendant on the record so that we don't have discussions in the back hallway.
Maybe there was nothing to discuss here. If the item was not in evidence and the clerk knew it and the court officer knew it, and the judge doesn't remember whether he even saw the note, maybe there was nothing for counsel to discuss. If it's not in evidence, it's not in evidence. You can't see it.
But I submit that even if we assume in cases where something is not in evidence and the jury requests something that's not in evidence, they're just told it's not in evidence, that is where the judge has made that ruling on the record in the presence of the jury. A court officer who tells the jury, for example, they request something the judge has excluded.
But that happens a lot. For example, if you give a witness a piece of paper to help them refresh their recollection, that piece of paper doesn't go into evidence. It's likely that a juror may say, let's see that piece of paper, and then you've got to tell them, or somebody has to tell them, it's not in evidence. But why does everybody have to reconvene and bring the defendant up from the pens, et cetera, to
I
do
think
that?
the better rule would be that when the jury is confused about what's in evidence and what's not, the parties should reconvene and they should be instructed.
Well, here
But the
there's
only
something
rule-
on the record that indicates there might be confusion, right? I mean,
Here-
is that the argument?
Exactly. Here, I'm asking for a much narrower rule, which is here, the jury was told this was admitted into evidence. In their presence, they were told it was admitted into evidence, and then they requested it, whereas the ruling, when the court realized its mistake, that it admitted when it didn't mean to, it meant to only mark it as an exhibit, the court, in a sense, unadmitted the exhibit outside the presence of the jury. So the knowledge of the jury is such that they believe this is an admitted exhibit they're entitled to, and therefore effectively failing to give it to them or having a court officer tell them this is not an admitted exhibit is contradicting what they've heard from the judge and providing them with information.
How does what you're asking fulfill the purposes that ORAMA was concerned about, to provide adequate notice and to have the parties participate in formulating a response to the jury if the response is going to be the exhibit you're asking for is not in evidence?
Well, first of all, the response would be more than simply that it's not in evidence. It would presumably involve some kind of explanation as to what happened, why they were told it wasn't evidence and now it's not.
Why do they have to give them an explanation? Why couldn't the judge just say it's not in evidence?
Because where the jury has heard a specific ruling from the court and that ruling has been countermanded, that at least ought to come from a court. And one of the rules of ORAMA, one of the purposes of ORAMA that we'd be satisfied here is we wouldn't have parts of the trial taking place in the hallway, off the record, and where a court officer is giving some explanation. We don't even know what it is. We don't even know that there was any explanation given.
I'm just trying to figure out how brittle ORAMA has to be.
I submit that where there is any issue.
It's a pretty drastic result.
Well, in cases where I think this is a pretty unusual circumstance, where you've got something that's admitted in the presence of the jury and unadmitted outside the presence of the jury, and that so that it doesn't require a wholesale series of reversals under any circumstance. And this rule, the reversal here doesn't require reversal in all cases where something is clearly was never admitted on the record, and therefore the jury doesn't have to be told something new. But here, a court officer telling the jury this is not an evidence is effectively overruling what they heard from the judge.
I'm sorry, Mr. Record. Do we know whether they received this or not?
We don't know. We really don't. I mean, one of the things that was...
I'm sorry. So the deputy or the court officer, him or herself, could have believed it was an evidence and given it to the jury mistakenly.
Correct.
We don't know that.
Correct. And that was one of the things I
Didn't
tried
the
to cover
appellate
in my
division
brief.
find that this was not sent to the jury?
No. What happened was when the judge was informed of this originally, that this was a reconstruction hearing which largely consisted of just the recollection and discussion of counsel, the judge's initial response was, well, this is an exhibit. Obviously, they got it. Those just go in. And then it was pointed out to the judge that it was only marked as a court exhibit.
So really, he did the presumption of regularity both ways during the course of this little dialogue or hearing or whatever.
When he believed this was an exhibit, he just assumed they got it.
It got in, and then he said, no, then it didn't get in, right?
And he said it's just a court
We don't
exhibit.
give things that aren't exhibits to the jury.
Right. They do say, the appellate division says, there's no indication in the record of the reconstruction hearing the jury was provided with that statement. There's a presumption of regularity that may be overcome only by substantial evidence. Defendant failed to rebut the presumption at the reconstruction hearing. Aren't we bound by the appellate division's conclusion that the jury never got the document?
No. I submit that there's a couple of questions in there. It's not a finding of fact. They're just finding that there was insufficient knowledge. But the insufficient knowledge is a function of the error.
That presumption sounds like a finding of fact to me.
And also I submit that the one thing that I submit cannot be the basis of the decision is the presumption of regularity, because this was not a regular proceeding where we don't know what happened, where there's a note from a jury, we have no idea what happened, we have no idea who said anything.
Well, aren't two presumptions of regularity better than one?
They might be, but I just, this is not, this can't
Well, he
become a
knows
regular.
that it's not his practice or practice of court personnel to give the jury exhibits that are not in evidence.
Correct, but we don't know whether the jury thought it was in evidence. Maybe the court personnel did as well. I mean, one of the fundamental problems here is that we have no idea what happened at this trial. You essentially have a sort of two sets of books here. One set of books is the public set, which is the transcript of what went on, and there's another set of books that's what actually happened in the hallway, and we have no idea what was told to the jury, if anything was told to the jury. Maybe there was no response at all.
Was that exhibit marked?
Pardon me?
Was that exhibit marked?
Yes, and it was initially admitted into evidence. It was only subsequent to that the court decided that it was a court exhibit because that was the initial, to avoid a Wade hearing, there was an agreement amongst the parties that would only be usable in rebuttal and so on. But to my mind, the critical fact here is that there was uncertainty with regard to the nature of the exhibit. The jury had requested the exhibit, and therefore substantive discussion was required. And under this Court's decisions, and Orama and others, that as soon as you've got the need for a substantive, as soon as you've got a substantive note, the need for a substantive decision, the parties have to be recalled. And the alternative is this sort of, this level of uncertainty, where you've got a criminal trial taking place in New York State where we just don't know, and we will never know what happened. And I don't think that should be expanded to the point where we potentially have many trials in which we're having a discussion at the Court of Appeals, which we're saying, I don't know, deputy probably told him something.
But the alternative is to reverse and order a new trial every time we get a confusing situation like this where we can't figure out what happened.
Well, in most cases, I don't think there's going to be reversal required, because in cases where it's clearly admitted on the record and it stays admitted, they just get provided with the exhibit, and there's no need for a substantive discussion. In cases where it's always clear that the document was not admitted, then there really isn't anything to discuss there, and it might well be the case that.
But when it's not clear either way, you do the whole trial over again?
Pardon me?
When it's not clear either way, you have to do the whole trial over again?
When it's not clear such that the note is substantive and requires the parties to discuss what should happen, then yes, I think a new trial is required.
And what was substantive about this note?
What was substantive about this note was that while the jury believed they were requesting an admitted exhibit, because that's the way things were left in their presence, they were not actually asking for an admitted exhibit. They were asking for something that had been unadmitted.
Isn't there a difference between a confused, non-substantive question and a substantive question?
No, I think the fundamental question when juries give out notes is asking for the law or the evidence before them, and where they evince evidence before them, especially something as important as a signed statement of the defendant pertaining to the very facts of the case, that confusion renders the note substantive.
Okay, thanks.
Good afternoon, Your Honor. Stephen O'Brien from the Monroe County District Attorney's Office for the People.
Counsel, you agree it's a substantive note?
No, I don't.
Yeah. Why not?
Well, as I understand the argument of counsel, the substantiveness comes from the fact that it was initially received by the judge, and then later the judge changed his mind and didn't tell the jury he changed his mind. I don't think it's substantive. It wasn't an exhibit. If substantive means we have something to discuss, I don't know what this judge was going to discuss with the jury.
Well, no, let's assume that it was a confession.
But it wasn't.
Right.
All right, but I'll assume that.
And the judge says, I'm going to admit this in evidence, and the jury knows it's in evidence now, and they're going to see it when they go back into the jury room. And then for some reason he reverses himself and says, I'm not going to admit this confession into evidence. And everybody goes home, and the deputy's there, and he's got the stack of exhibits, and they ask for the exhibits, and they get the confession. Isn't that a substantive problem? I understand that it's a procedural note when it says, give me exhibit number 1, but if exhibit number 1 is a confession, that's a serious problem, isn't it?
Well, it's a problem, but I don't know what the judge would say other than it's not admitted.
Right. What he should have said was to his court officer is, exhibit 1 is no longer on the pile. Take it off so that if they ask for exhibit 1, call me, and I will explain to them that exhibit 1 is no longer, before them, because it's an important issue that shouldn't be left to a court office.
That's a good suggestion.
Suppose a case.
What?
Suppose a case in which you've got something gets testified to,
all right,
and something pretty prejudicial, and the judge thinks about it and says, I shouldn't have let that in. And he strikes it from the record, and he denies the motion for a mistrial, and he gives the jury a strong limiting instruction, say that's not in, and I want you to disregard everything you heard. The jury goes out to deliberate. First question, can we see a copy of that thing? Doesn't the judge have some obligation? Doesn't the judge have the obligation then to say something more than, no, you can't, it's not in evidence?
I don't know how much of an explanation a jury is entitled to from the court when it's making rulings. As a matter of fact, I think...
But doesn't there come a point, if the, suppose, bring back Judge Pickett's confession. A confession goes in and then gets stricken.
All right.
Maybe you've got a mistrial already, but assume that you don't.
Okay.
A concession, the judge thinks he's going to try to get by with a strong limiting instruction. He sends the case to the jury, and the jury comes back and says, let's see that. Let's see a copy of that confession. Doesn't the judge at least have to say, wait a minute, you didn't listen to me the first time. There is no confession. You've got to disregard the confession.
Perhaps if the defense counsel says, Judge, I'd like you to give them that instruction.
Well, of course, the judge,
In this
if the defense
particular
counsel never
case-
found out the inquiry was made, it would be a more serious problem.
Right. But in your hypothetical, and in Judge Pickett's hypothetical, what's left out of both is the fact that the substance of the statement was already given to the jury in the testimony.
That's harmless error, you argue.
Yes. I think that there two things could have happened. Either the jury got the note or they didn't get the note. And if they didn't get the note, I don't know what the problem is other than ORAMA wasn't followed. But I don't think ORAMA really applies to this situation because the judge never got the note. I think there's been an implicit concession that the judge never got a note. So if the jury didn't get the note.
Doesn't it make it worse? I don't mean to interrupt your scenario, but doesn't it make it worse if the jury says, give us the gun, and there wasn't a gun, but he gives the deputy thinks this is funny, I'll give him my gun, and they get the gun, and they do something stupid, and nobody knows that they even made a request and that something like that happened. I would be more comfortable if the note came out and the judge said, look, do what I told you to do. I'm busy. If they're asking for an exhibit, give it to them. But not to ever know that a jury has requested something. And I don't think that strengthens your case. I think it weakens it.
Then I withdraw it.
Okay.
Well, the fact that it was marked as a court exhibit and became part of the court file, the court had it, even though the individual judge has no recollection of actually ever seeing it.
Right.
But it did become part of the court file.
Okay.
Correct? Am I correct?
Correct that it became part of the court's file. And there's definite speculation that's needed no matter what way we resolve this. Unless we go to the end and find out that no matter what happened, it didn't matter in this particular case because the contents of the statement were already known to the jury. The statement
Angel Cruz's statement, right? That's
is a paragraph long.
Right.
The
illegible paragraph.
It's pretty illegible, although I made it out, but it took me a while. The officer testified generally to the substance of the statement.
Officer Johnson.
Yes.
Right.
And the defendant testified in accordance with that statement except for that last part about how I took the knife from him.
All right.
Yeah, but it was only, they're only to know it for certain purposes, right, according to the stipulation.
I'm sorry, Judge?
They're only to know it for certain purposes, right?
They're only to know what?
The jury. To know about the statement, right? There's the stipulation in lieu of the Huntley hearing, right?
The stipulation in lieu of the Huntley hearing.
Yeah. Says that it's only to be used. Go ahead, you tell me.
For impeachment.
Right.
Obviously.
It's not evidence in chief.
No.
And the jury's supposed to understand the difference.
Right.
And doesn't their writing that note suggest that maybe they didn't understand the difference?
And doesn't that make it important?
Number one, we're all presuming that the jury sent that note out. I don't know that that's the case. It may have come with the verdict form. I don't know that. But
is that a mode of proceedings error, then?
Oh, I think if there is error here, it's, in the mode of proceedings, Orama talked about this. It's a mode of proceedings type of error that doesn't require preservation. We're not arguing no preservation here. Nobody knew about the note.
Why would it have been marked Court Exhibit 3? Somebody knew about it.
Sure, somebody knew about it at some point. No question about it, Judge. But I'm saying if we have to engage in guesswork, we can guess that just as easily as we can guess anything else. Bottom line, though, is if you look at the statement, even if they got the statement, there's no harm. The officer testified to the contents of the brief statement. There was no objection to his oral testimony. The statement itself was found not inculpatory enough that the prosecutor wanted to use it on his case, except for impeachment. The defendant testified in accordance with the statement, except for the last part.
Well, there was a reason why it wasn't admitted, though.
Well, I guess that's true. I don't know what the reason was. There was no stated objection. In looking at it, it seems to me the only way that objection would have been sustained is on the nature that the evidence was cumulative, because the testimony was let in.
Or in violation of the agreement of the parties that
No, the agreement with the parties, it could be used for impeachment.
Right, but that it would not be admitted into evidence.
Well, Mr. Owen said, I'm going to offer People's Exhibit 28 at this time as a prior inconsistent statement, Your Honor, so the jury can look at what he said to Andre Johnson the day it happened.
Right.
Mr. Reyes, objection. The court will receive it. Move on. And then later on, the court, I can put on the record that apparently there was some misunderstanding about what I received and what I didn't, and I may have misspoken. The item marked for identification number 28, I did not intend to receive as evidence, and for some reason it got in. The record received, and I didn't receive it, so we'll leave it that way. You objected, defense counsel, is that right? Mr. Reyes, yes, I did, judge. The court, yeah, I thought so.
Your Honor, I think when the judge ruled it inadmissible during the cross-examination of the defendant, I think the judge was right. And when he went back and thought about it, he said, I don't think it's admissible. And I don't think it was admissible then.
Yeah, but again, doesn't that note make you think that they thought that it is an admitted exhibit?
Yeah, I'm willing to
isn't that the logical presumption?
To the same extent.
And it's not supposed to be admitted, so do we just blow that off? What's the?
No, to the same extent as the judge pointed out, that they may think that something that is refreshing recollection is an exhibit.
Well, let me ask you this, Mr. O'Brien. If they had come back and said that they wanted to hear the testimony of the officer reading this statement, would that be a substantive request in your view?
Yes.
All right. And wouldn't the defense counsel say, well, I don't mind them hearing that, but, Judge, I think you ought to also give the defendant's direct and or my redirect of that officer. You know, I don't want you to just read that portion. I want you to read something else.
He could have said that.
And none of that happened here because, of course, they just got this, did or didn't get the statement. So none of that was able to be put in front of the jury.
Right.
Okay.
But I just want to make, if I make nothing else clear, I want to make clear that when you get to the bottom line and you look at this statement and match it up with what the officer testified and what the defendant testified, there's just no harm here. If, however, the harm is seen, as I think Mr. Eckert pointed out, just in the fact that ORAMA wasn't followed, it doesn't matter what the result was.
Isn't that the approach we've usually followed? If we find ORAMA error, we don't look to whether it's harmless?
I think there are some cases where ORAMA, where this court, I believe, found that although there was an ORAMA error, it didn't prejudice the defendant.
Yeah, but isn't the law basically it's inherently prejudicial, even when there's no specific prejudice? Isn't that what ORAMA is all about in this kind of very specific situation?
To a certain extent, I think that's true. But I think what should be kept in mind is that ORAMA contemplates a situation where a court is faced with a note and what the court should do. The court here wasn't faced with a note. The court didn't violate ORAMA. ORAMA applies to those situations where the court is given a note. I don't think ORAMA has any application.
Suppose they'd given the
principle that the jury
Suppose that the jury had given a substantive note to the court officer, and the court officer for some reason failed to deliver it. He rushed off to see his girlfriend or something. Has there been a mode of proceedings error?
That the judge never got the note? Mm-hmm. If there's error, I think it's a mode of proceedings error.
It sounds like error, doesn't it? It doesn't sound good.
What's in the note?
Well, I said a substantive note.
All right.
So you would agree that would be mode of proceedings error?
I think this Court has determined that.
And then the question is whether this note is substantive, right?
If it's – when you're talking about substantive, sometimes we're putting, the cart before the horse. Substantive is what they decide after they decide there's been a sufficiently serious ORAMA violation. Again, I don't think ORAMA has any application to a case, and there may be another case, but I think ORAMA deals with those cases where a judge is given a note and what that judge's duty is. And I don't think that is an application.
Take it away. Yeah, a jury sends in a note saying, "Remind me, was it reasonable doubt or preponderance of the evidence that we're supposed to be following?" That note never makes its way to the judge, so it never gets answered. That's a mode of proceedings error, isn't it?
I believe it is, and I think this Court would have to make a determination. But I don't think it would make that determination by saying, ORAMA, therefore this. I think ORAMA deals with an entirely different set of problems.
Okay, Counsel.
Thank you.
Counsel, rebuttal?
Yes, sir. Thank you. With regard to harmless error, anytime there's a response to a jury note in an ORAMA situation, it's inherently prejudicial. The only time the question comes up with regard to whether something is sufficiently prejudicial in cases, I think, where there's no response whatsoever. And here, where the lack of clarity of the record leaves both of those possibilities open, I think there has to be I submit there has to be reversible error, because it can't be the case that because we don't know what happened, therefore it's less likely to be reversible error.
It is true, though, that ORAMA really took great pains to go through the procedural steps that the judge has to follow.
Absolutely.
Once given a note. So, I mean, this may be son of ORAMA, but it's not exactly ORAMA.
Well, in terms of how the notes should be handled and why they should be handled, I think this is sort of an example of why ORAMA is necessary, why we wouldn't be here having this discussion if those procedures had been followed. And with regard to harmlessness of the statement itself, this is a statement of the defendant pertaining to the very question that's on trial here, where his credibility, I submit, is critically important. If the jury believes his testimony that he didn't stab these people, then he should be acquitted. And finally, I think the fact that the jury has specifically requested this statement is an indication that they consider it to be important, and that therefore the failure to give any response if that's what happened, or providing them with a note if that's what happened, in either situation, it's not harmless error. It's very harmful to Mr. Cruz, and that this can't be the proper way of handling notes like this. Thank you.
Okay, thanks. Thank you both.